In 1750, in the commune of Vanves near Paris, a local man was caught in a field committing what the law then rigidly defined as a crime against nature. But the authorities didn't merely arrest the man. They hauled his accomplice into court too. The accomplice? A 4-year-old female donkey. In 18th century France, you have to understand, this was no village prank. It wasn't some symbolic ceremony. This was a high-stakes criminal trial. The beast faced the exact same terrifying penalty as the human: death by fire at the stake.
That was the stark, inescapable reality of the era, a silent farm animal staring down the absolute force of the state. To grasp exactly how a creature of the fields ended up standing in the criminal dock, the underlying system of power, belief, and ultimate judgment must be examined.
The legal landscape of the Ancien Régime dictated the terrifying stakes of this high-profile criminal trial. This was the political and social architecture of the Kingdom of France prior to 1789. It was a system where justice was heavy, absolute, and inextricably intertwined with divine law. This architecture reveals a profound psychological divide between the modern mind and the 18th century jurist. Today, our legal framework categorizes animals strictly as property, but centuries ago, the view was vastly different. Animals were perceived as true legal subjects. They were believed to possess intention, cold calculation, and even malice aforethought.
Under the strict penal codes of that era, bestiality, or buggery, was viewed as a shameful act that corrupted the public moral fiber. And because this morality was so deeply tied to religious dogma, a forbidden congress between man and beast assumed that both parties had consciously consented to the evil. It wasn't just a crime. It was treated as a literal form of diabolical possession.
Jacques Ferron, the human protagonist of this dark legal drama, was caught in flagrante delicto, caught in the actual commission of the offense out in a public field. That singular legal condition triggered a rapid descent into the absolute maximum penalty, securing an immediate capital offense charge. This suffocating reality enveloped both the accused. Man and beast were forced through rigid, identical legal procedures. They were thrown into the exact same prison. Lawyers were appointed at public expense to defend their respective interests. Witnesses were formally summoned to testify. The town methodically, almost clinically, prepared for a dark spectacle of retributive justice at the hands of a professional executioner.
The trial reached its inevitable climax. The evidence against Jacques Ferron was absolute. It was overwhelming. He was sentenced to be burned alive, his fate permanently sealed by the unforgiving statutes of the era. But the mystery deepens when we weigh the fate of the animal. The proceedings took a courtroom turn that completely defies our modern logic. Father Pinterwell, a local prior of the convent, stepped forward. He didn't come as an eyewitness to the crime. He came as a formal character witness for the defense of the donkey. The sheer bureaucratic gravity of this defense is staggering. A complete life timeline was presented to the court. She was born in 1746, caught in the act in 1750. And on September 19, 1750, a formal signed certificate was submitted by the defense. This wasn't just a slip of paper, it was backed by leading citizens of Vanves who swore a binding oath to the donkey's morality.
The profound, deadpan sincerity of this legal claim is hard to wrap your head around. The priest's written affidavit solemnly declared that she was, in word and deed and in all her habits of life, a most honest creature. Think about that. A high-ranking official, under oath, legally vouching for the word of a creature that fundamentally cannot speak.
The defense constructed a masterful, impassioned argument. Because she had been known by citizens for 4 years to be virtuous and well-behaved, they reasoned she could not possibly be a willing participant. They pleaded before the tribunal that she was a victim of violence, a creature forced into the situation entirely against her own free will.
The tribunal was forced to deliberate on perhaps the most unusual question in legal history. Did the animal refuse consent? Moved by the sworn account of her honorable life, the magistrates delivered their verdict. She was acquitted. She was legally absolved of sin and quietly returned to her pasture.
This specific conclusion poses a haunting, inescapable question. If the donkey was innocent, why was she in court in the first place? Why did a literal beast of burden have to prove her virtue before a judge just to avoid the flames?
The answer lies in how our ancestors perceived existence itself. To them, the entire world was a literal battlefield between God and the devil. Every living thing, whether walking on 2 legs or 4, was considered an active moral agent. There was an absolute, terrifying accountability for the purity of life.
This trial stands as a distant mirror for justice systems across centuries. It reflects an era that didn't merely police outward behavior, but systematically attempted to police the very souls of every creature under the sun. It forces a lingering thought. If an entire society can project moral agency, complex intention, and legal guilt onto a silent animal, what implicit judgments are being projected onto the voiceless subjects of our legal systems today?